Welcome to Family Law War Room with Brad LaMorgese.
Welcome to Family Law War Room with Brad LaMorgese. Brad is a board-certified family law attorney in Texas who specializes in high-stakes divorce, complex property division, jurisdiction disputes, and family law appeals. I'm Shameika Rhymes, and today we're talking about family law appeals in Texas and what happens when a trial court gets it wrong. Hi, Brad. How are you?
Doing well. How about you?
Doing well. I'm so glad to see you. Well, let's dive right on in. What types of rulings in family law cases most often lead to appeals, particularly in high asset divorce or complex custody disputes?
In family law, appeals most often come out of cases where discretion intersects with complexity. So in high asset divorces for a property division, you're really looking at how a trial court would characterize the assets as separate or community, how it might value a closely held business or even a non-closely held business, or how it would handle tracing and reimbursement claims. And even small legal errors in those cases can swing millions of dollars. In custody cases, we're not really looking exactly at the custody determination because it's very discretionary, but you're looking at cases with interesting legal issues like relocation or relocation restrictions, situations where a court may admit an expert in a custody case, or in custody cases in particular jurisdiction disputes, although that's a common appeal in any kind of a case.
Well, how is an appeal different from filing a motion for new trial or asking the trial court to reconsider its decision?
It's a very important distinction because a motion for new trial or reconsideration will go back to the same judge to point out errors. And sometimes that works, not usually. Judges don't typically want to do redos, but it is also a way to preserve error to claim later in the Court of Appeals. And occasionally you'll see trial courts grant those. An appeal is totally different. You're no longer asking the trial court to do anything. You're at a higher court with usually 3 justices considering, did the court follow the law? And appellate courts don't hear new evidence. They're simply looking back at the written record of filings and petitions and orders, and then also the reporter's record with the evidence. Strategically, motions for new trial preserve the issues or even fix problems that you want to complain about later or defend about later on appeal.
Well, what has to happen during the trial itself to preserve issues for appeal, and how do these decisions unfold while the case is still being litigated?
Appeals are generally won or lost at the trial court level, and preservation can be everything. That means timely objections, clear rulings, and making sure the record reflects exactly what happened. If evidence is excluded, you'll have to make an offer of proof. Or if the court applies a wrong legal standard, for instance, that needs to be raised contemporaneously. Same with jury instructions or a court's findings. Now, those decisions unfold in real time, often under pressure. Trial counsel has to be steps ahead, basically thinking about this early in the litigation. How am I presenting evidence? If this goes sideways, can we appeal it or defend it? That appellate mindset during trial is critical, and often early on in complex cases where legal nuance matters, it's critical to be thinking about that.
Well, speaking of, how do appellate courts in Texas review family law decisions, and why does the standard of review matter so much in these cases?
The standard of review is often the whole ball game. So in family law cases, many rulings are reviewed for an abuse of discretion, which is literally the most friendly standard to upholding the trial court on appeal. The appellate court is typically not re-looking at everything. They're looking at it through a specific lens. Now, on the other hand, there's much less deference to legal questions like statutory interpretation, potentially character of property, or anything where there's a true legal application. That's reviewed de novo, which means there's no deference at all. So understanding which standard applies frames the entire appeal. It dictates how issues should be argued, what cases matter, and how realistic reversal actually is. A strong appellate strategy starts with that mindset.
Wow, okay. So in complex family law matters, how does the possibility of an appeal influence strategy before the trial court even makes its final ruling?
So in high stakes matters, appeal often should be in the back of everybody's mind from day one. And there's those cases where everyone knows somebody's going to appeal it because the stakes are so high, whether that be a relocation to a faraway state or country, or a huge swing in assets, depending on valuation or character. And it also can affect settlement posture. If one side knows a ruling is legally vulnerable, that risk can drive resolution. Other times, trial counsel will intentionally build a clean record, knowing the case might be decided on appeal. So the key here is intentionality. You don't litigate differently because you want an appeal, you litigate because you may have one.
Well, when a trial court makes an error, what determines whether the court can actually correct it?
That's a great question, too, because appellate courts look whether the error was preserved and whether it probably caused an improper judgment, is the magic language. Mm-hmm. So every court of appeals is always going to engage in harm analysis. Some mistakes, like applying the wrong legal standard, can be very harmful. Other mistakes, like admitting the testimony of a sort of a tangential witness that didn't harm the whole case, won't be harmful error. There's literally appellate opinions saying you're not entitled to a perfect trial. And so it's connecting those dots between error and harm.
Well, thank you for that. I was about to ask what kind of errors could happen. And so that's helpful to know that, those examples that you just mentioned. Now, once an appeal is filed, how does the process typically unfold and what timeline should parties expect?
Well, it's not for the faint of heart always, and it's not instant gratification. But when you're filing a notice of appeal, the record is assembled. As I mentioned, the filings in the trial court, the reporter's record of what happened at trial with the evidence. And in complex family law cases, then the briefing will begin, 30 days for the first brief, subject to extensions. And this process can take many months. Oral argument, if granted, will be several months later, and then you're seeing a decision in the case even months later after that. So from start to finish, this is a deliberate, methodical process. One exception would be if an appeal happens during a case, it's typically called a mandamus. That can be much more expedited because it's usually filed or granted on emergency matters.
What might those emergency matters look like?
In family law, that will be a temporary order in particularly a custody case, because those aren't appealable. It may involve standing of the parties to be involved in that kind of a case, jurisdiction issues, or even discovery is the sweet spot of if you don't have the right documents and evidence for trial, or if you're being asked to release too much, those can be addressed right away.
Oh, okay. Well, how can an appeal affect enforcement of the original ruling, especially when property division, custody, or financial orders are involved?
In family law, enforcement is tricky because filing an appeal doesn't automatically stop enforcement. Some orders like custody are basically going to go forward unless stayed. Property divisions generally will go forward as well, although money judgments or things that can be superseded, as they say, or stayed, there are methods to be able to post bonds or tie up cash to make sure that those are intact. So this creates real world pressure because parties are often having to comply with orders, maybe simultaneously challenging them. And so those are very important decisions that get made early on in the appeal.
Now, when evaluating a flawed trial court decision, how do you determine whether an appeal is the right move versus pursuing a different procedural option?
to determine is this case right for appeal, which is the first conversation we have. It starts with an honest risk assessment. What's the standard of review, like we talked about? Is there harm? Was the issue preserved meaningfully? And then what are the costs? Financial, emotional, strategic. So sometimes this motion to clarify or modify or even enforcement is more effective. Other times, appeal is the real viable path to correcting legal error. The right answer depends on the law, the record, and the client's long-term strategic objectives, and whether they can live with this result or not.
Well, Brad, this has been such an informative conversation. Thank you for breaking this down for us today.
Thank you.
Well, that's it for today's episode of Family Law War Room with Brad LaMorgese. To learn more about Brad and his work in complex family law matters, visit lamorgesefamilylaw.com. Thanks for listening, and don't forget to subscribe, share, and leave a review.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.